YouTube as always. Let me share my screen. I'm just waiting to share. Okay, just give me a thumbs up that you can see the screen. It's just the usual sheet that I'm used to type up the class notes while I teach. So we're busy looking at the duties of the seller in a contract of purchase and sale. What we've learned so far is that every contract, let me go up. We started off with the law of contracts in general. Now we're looking at special contracts, specifically currently the contract of purchase and sale. We've learned so far that it's important to be able to classify a contract, to know whether a particular agreement is a contract of purchase and sale, because different types of contracts have different legal consequences, implied terms, terms that will always apply unless they have been expressly excluded. Now we are busy looking at the duties of the seller, the implied duties. Please keep your mics muted. The implied duties of the seller, duties that a seller will always have unless they have been expressly excluded. We've looked so far at the duty to deliver the thing, which is also coupled then to the guarantee against eviction. Contract of purchase and sale only gives you the right to delivery, not an automatic right to ownership. But together with the right to delivery, there's an implied guarantee that you will not be evicted, that nobody with a better right will come and take the thing away from you. Moving on then to the seller's duty to keep the thing in safe custody. Now I'm going to teach you some things here that you will find unusual. And I have to urge you in advance to think with your heads, not with your hearts. This is one part when we get to it specifically, there's one part that of all the years that I've taught this, over and over again, students say to me, but I don't understand this. They don't understand it because they're thinking with their hearts, because they think, but that's unfair. Forget about that. This is how the law works. Now, first of all, let me point out to you, just for the sake of understanding, that this seller's duty to keep the thing in safe custody is only relevant. It's inherent, it's implied in all contracts of purchase and sale, but in most instances, contracting and delivery take place at the same time. When you go and buy a loaf of bread, you walk out of the shop with it in your hand. So contracting and delivery has taken, and then the duty to keep it in safe custody, although it will apply because it's implied, it's inherent to all contracts of purchase and sale, will not be relevant. This duty to keep the thing in safe custody is only relevant when there's a time period between contracting and delivery. So if delivery takes place immediately, this is not relevant, because then the purchaser already has the thing in their possession, they have taken delivery. This is relevant if there's a time period. So we agree on Monday that you will buy my phone and you will collect it on Friday. So between Monday and Friday, it is still in my possession, and you will only get it on Friday. Now, during this time, the seller must be in safe custody. So if you bought my cell phone on Monday and you're collecting it on Friday, but in the meantime, I leave it lying outside or in my car, in an unlocked car, and it gets stolen, it means I have not kept it in safe custody. So any damage, any loss or damage caused by the seller not keeping in safe custody means the seller is liable. So that's just straightforward breach of contract. The seller has the duty to keep the thing in safe custody. If they didn't do that, they didn't do something that they were contractually obliged to do, and they are liable. So far, so good. But now in a contract of purchase and sale, there's a twist known as the passing of the risk. Or in certain texts, it will be referred to as the risk doctrine. And this is where students start coming to me and say, but they don't understand the passing of the risk rule. It's easy to understand. Think with your heads. Passing of the risk rule. Now, first of all, this is unique to purchase and sale. If it's a lease agreement or a contract of exchange or a bartering agreement, whatever, the risk rule will not apply. It applies only to purchase and sale. The risk rule reads as follows. If the contract is perfecta, the risk of, so to see my words here, accidental damage watches to the purchaser. Now, what does all of that mean? First of all, the term is perfecta, not perfect. It's a legal term. Perfecta. You can also, if you can't remember the word perfecta, use the word complete. So when the contract is complete, the risk of accidental damage passes to the purchaser. I'm going to get back to that. When is a contract perfecta? When the price is fixed or ascertainable, when the thing has been specified and when the contract is not subject to a suspensive condition. So this is similar to the requirements for a valid contract of purchase and sale, except for this last one. If the contract is not subject to a suspensive condition. What is a suspensive condition? That is a suspensive condition. When we did conditions and suspensive and resolutive, I told you the reason why I'm doing this is because it becomes relevant later. Now, this is later. So you should know by now, you should have an understanding of what a suspensive condition is. So if there is no suspensive condition, the price has been fixed, the thing has been specified, and there is no suspensive condition. What happens then? If those three factors are in place, the risk of accidental damage or loss passes to the purchaser. And the implication of this is that if the thing is damaged due to circumstances beyond the control of the seller, so just to point out, the seller must keep the thing in safe custody. If the thing is lost or damaged because the seller did not do this duty, so caused by the seller not keeping the thing in safe custody, is liable. But if this damage was beyond the control of the seller, so he kept it, tried his best to keep it in safe custody, but something bad happened. The thing is damaged due to circumstances beyond the control of the seller. The purchaser bears the risk, must still pay the full purchase price. And this is where immediately everybody tells me, but I don't understand this, miss, because it sounds unfair that now the thing is damaged or perhaps completely destroyed. You're not getting anything, but you still have to pay the full amount of money. Now your brain shuts down and says, but that's unfair. I don't understand it, miss. Think with your heads, not with your hearts. Doesn't matter whether it's fair or not fair. That is how the law of purchase and sale works. If there was any damage to the thing due to natural circumstances, the horse was hit by lightning, purchaser still has to pay the full purchase price. Is everybody with me? Any questions about this? So in the notes, there's a little bit of discussion about those three factors. The requirements for the contract to be perfecta, namely that the price must be fixed or ascertainable, the thing must be specified, and the contract is not be subject to a suspensive condition. So just look at the notes there for that further detail. Remember, just be careful here. There's three requirements for the thing to be, for the contract to be complete, to be perfecta. Nowhere amongst those three requirements for the contract to be complete is there any requirement that the purchase price must be paid. That's a common mistake that I get students telling me, but it's not perfecta because he hasn't paid yet. Payment is irrelevant as long as the price has been fixed or ascertainable. Doesn't matter if it's been paid or not. They must just have agreed on the price. So I'm just looking at the notes here to make sure I haven't missed something. I have covered everything. What isn't specifically stated in the notes, but I need to explain this to you because maybe it's going to make you feel a little bit better. When does the risk rule not apply? This is a natural legal consequence. It's an implied term. When does the risk rule not apply? Obviously, if the contract is not perfecta, only starts applying once the contract is perfecta. If the damage due to the fault of the seller, so he didn't keep it in custody. Just checking here quickly. And then also, okay, yes, it is actually in here. I have to check now because I'm busy setting your test. And I just want to make sure I don't have things in your test that aren't actually in the notes. That's why I was stopping now. But no, this is in the notes. So if the contract is not perfecta, if the damage is was due to the fault of the seller by not keeping it in safe custody, if the seller did not deliver in time, so if the seller is in mora debitoris, the implication, just to illustrate this, if Magdalena bought my cell phone, I agreed with Magdalena that she would buy my cell phone, but we agree, it's Monday today, we agree that I will deliver it on Friday. Contract is perfecta. We've agreed on the thing, we've agreed on the price, there are no suspensive conditions. I have to deliver on Friday. So between now and Friday, I have to keep it in safe custody. But if the damage is accidental, something I didn't have any control over, the risk will have passed to her and she still needs to pay me the full purchase price. If I don't deliver it on Friday, come Saturday, because I am now in mora debitoris, I am now in breach of contract for not delivering on time. If on Saturday it gets damaged accidentally, I will be liable. So the moment delivery is late, the risk then moves back. Yes, Heiko?
Sorry, I just want to find out now regarding mora debitoris in this case. Is there an addendum attached? How do we proceed as of their out of interest sale?
Okay, first of all, Heiko, you still seem to be a little bit stuck on contracts having to be in writing. This rule applies even for oral. Remember, contracts being in writing is an exception to the rule rather than the actual rule. So if we have a contract of purchase and sale that's an oral contract, this still applies. But obviously you can't have an addendum attached to an oral contract. But the moment Friday has passed and I have not delivered to Magdalena, I am in breach of contract, mora debitoris. Then we go back to our rules of breach of contract. Got them here. Going to share this with you, these notes with you. Mora debitoris. So as agreed, if it didn't, we had agreed on Friday, Friday passed, I am in breach of contract. The risk moves back to me. What remedies does she have? Specific performance or damages. And this will always apply and be available to any contract. You don't need an addendum for this. Magdalena and I had an oral contract, but the fact that we had an oral contract or despite the fact that we had an oral contract, we agreed orally, word of mouth, Friday. Now it is Saturday. I'm in breach of contract. She can claim specific performance and damages. That applies to all. That's the beauty of the law of contracts, that you have all these rights and all these protections without having to have anything in writing.
Perfect. Thank you very much.
Yeah, when you buy a loaf of bread, you don't sign a contract with an addendum with a shopkeeper. Yes, sometimes, obviously, if you're buying a house or a car or something like that, you're going to get it in writing. But for smaller contracts, a loaf of bread, airtime, even a cell phone, no need to have it in writing. You've got all the protection, even if it's not in writing. Are you with me?
Yes, thank you very much.
But now this last one, when does the risk rule not apply? Happens very often, Heiko, in written contracts. Remember, it's an implied term. Parties can exclude it. When does it not apply? When the parties have agreed that it will not apply. You can also agree that orally, but this happens more often in written contracts. For example, it is very much standard when you buy property. If you buy a house, and buying a house, in terms of law, it has to be in writing and signed by the parties. And in your standard contracts of purchase and sale, of course, I'm saying standard now, it can change, but the ones that are normally used, they will be specifically, because for when you buy a house, there will always be a delay in time between when you've signed the contract, when you've entered into the contract, and until delivery has taken place, when the property has been registered in your name. It will take, there's at least 6 weeks, if not 3 months, between contracting and delivery when it's registered on your name. Now, according to the standard purchase contract of purchase and sale, the risk rule applies. So for that 6 weeks or 3 months, the risk has already moved to the purchaser. So if the house burns down, this purchaser still has to pay the full purchase price. But in all contracts of purchase and sale that I have worked with, and that's many of them, there is a standard provision that the risk attached to the property sold will only pass to the purchaser on date of transfer. So they contract out of the risk rule, protection of the purchaser during that time when the seller is still probably living in the house, etc., etc. The risk is on the seller, and the seller will be liable if there is any damage. Are you with me, Heiko?
Just out of interest, like the seller has then an insurance policy regarding that issue, if I'm not mistaken.
Hopefully the seller has an insurance policy, but insurance policy is not a requirement for home ownership. You would be stupid if you don't, but many people are stupid. So we hope they have an insurance policy. There's no guarantee that they have an insurance policy. If they don't, they have to just...
Sorry, this must be checked in the contract if there is an insurance, just to be safe, for yeah, safe keeps or whatsoever, when you are a wise purchaser.
Yes, of course. Everything that I've said so far, what I've explained about the risk rule, in fact, the words that you used, if you are a wise purchaser, this is one of the implied terms of a contract of purchase and sale that you have to be very aware of and be a wise purchaser and make sure you are protected. That's the beauty of this course. I'm teaching you how the law works and hopefully opening your eyes so that in a couple of years' time, when you're buying your own car or your own house or whatever, you are a wise purchaser and can make sure that these things are in place. Check that the seller does have insurance, that type of thing. So yes, insurance isn't a prerequisite for home ownership, but it's very, very stupid not to have it. So one day when you buy a house, please make sure you have insurance. I've seen too many people being left in uh, very, very bad situations because they didn't have. If you buy a car, please, 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 Heiko, and everybody else. Who owns a car? Give me a thumbs up quickly if you own a car. Please make sure that that car is insured. Heiko, do you have insurance for your car?
Definitely, yes.
Okay, good
Third
for you.
party,
Yeah,
but it is insured.
yeah. No, you might feel you don't want to pay the monthly expense of having insurance. Somebody else, a taxi crashes into your car. Even if it's the taxi driver's fault, your car is written off. The taxi driver doesn't have money to pay you. Your problem. Make sure you're insured. Okay, that's now besides the point. That was just like my little life lesson that I threw in here as well. Okay, so that is the passing of the risk rule. Those instances, it will not apply. If you are buying something big, make sure that you have protected yourself and that you have agreed at the time of contracting that the risk will only pass to you when you take delivery. Okay, so then there's one more. Moving on now. The guarantee against latent defects. This is the last of the duties of the seller that we are doing. Now, you know what a guarantee is again at this stage. So, what is a latent defect? A latent defect, and you need to know these requirements for a latent defect. They appear on page 48. Latent defect is a defect that at the time of contracting. So be careful here. This previous duty that we did, the duty to keep this thing in safe custody, refers to damage to the thing after contracting. The guarantee against latent defects is not something that goes wrong with a thing after the contract, but it is something which is wrong with a thing when you buy it at the time of contracting. renders the thing less useful or effective. So you can't fully use it for the purpose that you wanted to. It is so serious that a reasonable purchaser would not have bought it. Or would not have paid that price for it. It is not visible by somebody that looks fairly well. It's not visible by the precise person, and it was not known by the purchaser. At the time of contract. Not known by the purchaser. It doesn't matter whether the seller knew or not. That's not relevant. The purchaser did not know. So in order to have a claim based on the guarantee against latent defects, you need to prove that there was a latent defect by proving those 5 requirements. It existed at the time of contracting, renders the thing less useful or effective, so serious that a reasonable purchaser would not have bought it or not have bought it for the same price, is not visible by the precise person, by somebody looking well, and it was not known by the purchaser at the time of contracting. Michael, yes?
If I may ask, sorry to bother you so much this evening.
No,
Yeah, you may talk.
no, I said I enjoy your questions. Please go ahead.
I just want to know this latent defect clause. Isn't it usually part, or especially part, in the second-hand market, if I may state it like this? Yeah, there are always a lot of yeah, small issues or whatsoever, and especially in the second-hand market where you don't see immediately what's wrong or whatsoever.
Michael, you are quite correct. Give me one and a half page to teach, and then I'm going to answer you. Then I'm going to get back to exactly what you are referring to now. Remember, once again, I will get to it. But just to answer your question now, this is obviously the guarantee against latent defects is prevalent in the second-hand market for whatever, because you are buying second-hand goods. This is an
Perfect. Thank you.
it is an implied guarantee. And as I have said, also just even a little while ago, when we're doing the risk rule, that the parties can agree to exclude it. This is an implied guarantee, and we will get to the instances where it won't apply shortly. One of those is that parties can agree to exclude it. It's known, you might have heard the term already, a foot stewards clause. So if you're buying my car secondhand and I sell it to you foot stewards, it means we have agreed to exclude this guarantee against latent defects. And if you have agreed not to claim for latent defects, you won't have a claim because you have agreed not to claim. So that happens very often in the second-hand market, that the seller excludes this guarantee. You buy a second-hand thing, you buy it at your own risk. but it has to be expressly excluded. If as a purchaser you didn't agree and say, okay, I accept, I won't claim, this comes naturally with a contract of purchase and sale. So you have to prove that there was this latent defect. Now, just quick application of this. Magdalena, you're my victim tonight. I sold my cell phone to Magdalena, and the screen is cracked. Will she have a claim based on latent defects?
Not as far as my
Uh,
concern.
no, she
Okay, there's somebody else here. I can't see your name. Somebody else that also answered. Heike, you correct. The other one or person also said no. Benjamin, your hand is up.
But when you are selling your phone to Magdalene, you didn't say anything. You didn't express whether so you're going to sell it as it has a crack or not.
It's just we agreed on the price and the phone.
Oh,
And
you have
that's
agreed. Oh,
no, we
okay.
agreed on the. We've
And she
agreed on.
sees it. Okay, now Magdalene.
We've
Okay.
only, yeah, what we, Magdalena and I discussed is
Mhm.
the price and the phone.
Yeah.
The next day after she's
And
taken
she sees the
delivery,
phone or not.
she could look at the phone. She knows this is my phone. She had the right to
Oh.
look at it. When she gets
Okay.
home, she says, oh dear, there's a crack in the screen. Can she claim from me based on
Okay.
latent defects?
That's impossible, man.
Why will she not be able to claim?
She has agreed.
Agreed about what?
Now the price, and then you are delivering.
Okay, I'm going to get back to you now. I can't see, there's another lady whose hand is up, but I can't read her name on my screen. The other lady that put your name up, please speak.
it's Ngendina, ma'am.
Sorry?
My name is Ngendina.
Okay. What do you think?
Okay, and I know she won't have because it's not a latent defect. She can see that the phone is cracked. So she could see it, so she doesn't have the right to claim
Absolutely.
warranty.
That is what I was getting at. If the screen is cracked, in order for a defect to be a latent defect, it must not be visible by somebody that did a proper inspection. If the screen is cracked, if she had looked properly, she would have noticed that the screen is cracked. It is not a latent defect. If, however, she takes delivery of the phone, and when she gets home, she realizes it doesn't charge, will she have a claim against me? Magdalena realizes the phone does not charge. Will she have a claim against me? Yes or no?
I believe yes.
Why do you say yes?
Because she won't be able to see just by inspecting and by looking that it's not charging.
Absolutely, 100%. A cracked screen is not a latent defect. A cracked screen, in fact, is what we call a patent defect. Something that you can see. She would not, if she inspected the phone, have been able to see that it does not charge. So this is a latent defect. Patent defect, cracked screen, she could see it. Latent defect, she would not have been able to pick that up. So if she can prove those requirements, she will have a claim against. But now, the guarantee against latent defects is a little bit different from the normal rules of contract that we studied so far. All the other duties, we've seen that if there's no compliance with the duty, there is breach of contract and you have your normal remedies of either specific performance or cancellation and a claim for damages. With regard to the guarantee against latent defects, the remedies are slightly different. The remedies are somewhat special. First of all, you cannot always claim damages. For any other breach of contract, I've always said to you, there's always a claim for damages unless you can, or as long as you can prove that you actually suffered these damages. But for a latent defect, you can only claim damages you will only have a claim for damages in the following circumstances. If the seller is a merchant or a manufacturer, so a shopkeeper or somebody that makes things, there's a higher duty on them to ensure, because they are in the business of selling things or in the business of making things, there's a higher duty on them to ensure that there are no latent defects. A second-hand sale. I sell my cell phone to Magdalena. I'm not a merchant. I'm not in the business of selling phones. But if you buy a phone from the iShop or whatever they call, that is a merchant. So there's a bigger, heavier duty on them. If the seller gave an express guarantee. So if I told Magdalena the phone is in a perfect condition and it isn't, she will have a claim for damages against me. Heiko, your hand is up.
Yes, sorry. So this is basically the clause of warranty coming in here, specifying a producer or a manufacturer and a second-hand, meaning a seller, who is only selling the objects and not manufacturing or directly from the fabric selling the stuff.
I'm not quite sure I followed what you said now. Just explain that to me again or repeat your question.
Yes. So this aspect is basically concerning or regarding to the clause of warranty. The simple reason for that, a merchant has to guarantee that the object you buy is 100%, and the seller or a franchisee is verplig yeah, that he has to um, sell the object in 100% condition, whereas the seller can say, I didn't know that there was this fault on it, and he jumps free the smaller clauses or whatsoever regarding the law.
Okay, Heiko, he doesn't jump free. This guarantee is always implied. Even if I'm selling my second-hand phone to Magdalena, it is implied, it is always there. I don't have to guarantee anything. It is implied, unless I agree with Magdalena that I don't guarantee. But if we don't say yes or no or anything or speak about a guarantee, it is implied.
All right, perfect. Thank you.
Okay. Magdalena, your hand is up.
Sorry, ma'am. I'm so sorry to take you back, but I just wanted to ask regarding the latent defects. The example we gave, I buy a cell phone, then I come home and I discover that it's not charging. What if I buy a cell phone, I come home, everything is working, but then probably after 3 days or 4 days, I discover that it has some, maybe that's when it's not charging. Is there a time period to say it's
There's no, Magdalena, very good question. The law doesn't specify a time period. It doesn't say you have to discover it within 24 hours or whatever. You have to discover it within a reasonable time. There's another requirement, let's go back, that it must have existed at the time of contracting. So if you only charge the phone for the first time 4 days after you bought it, and you then discover, oh dear, it doesn't charge, you will have a claim. But if you've been charging it for 2 weeks, and suddenly in the 3rd week, it stops charging, you might have problems to prove that requirement, namely that it existed at the time of purchasing and that something didn't go wrong while it was in your possession. So whether you will be able to prove it or not will depend on the facts of the facts of the particular case. So there isn't a specific time period you have to claim it within 2 days or whatever. Your claim arises the moment you become aware of the defect. But if there's too long a time, then it might become difficult to prove that it existed at the time of contracting. You understand what I'm saying?
Yes, ma'am. Thank you.
Okay. But just Heiko, to get back to you, because you said then if you buy something secondhand and then you don't have protection. That's not correct. There's various remedies, and at the moment we're looking at a claim for damages.
All right.
You have but there are other remedies, so just hang on for a little bit.
Perfect.
A claim for damages exists only if the seller is a merchant or the manufacturer, if the seller gave an express guarantee. So I told Magdalena that it's perfect and it isn't, or if the seller acted fraudulently. So I gave an express guarantee, acted fraudulently, or related. I knew about this, the seller knew about this and didn't disclose it, so they acted fraudulently. But damages is not. So only in those limited circumstances can you claim damages. But it doesn't mean that in another instance that Magdalena now has to suffer the loss because she can't claim damages. There are other remedies. There's the remedy of cancellation and restitution. It means exactly what it says. You cancel the contract and give the phone back. She gives the phone back and I give her money back. When can you claim cancellation and restitution? When the defect is so serious that it goes to the root of the contract. I used to previously illustrated this by using also the cell phone. If it doesn't charge or you can't phone, then it's useless. But if the camera doesn't work that well, but you can still use the phone, the camera just doesn't work that well. It doesn't go to the root of the contract. With you young people having having a camera that works well, these days, I suppose you can say the camera doesn't work, also goes to the root of the contract. But cancellation and restitution, when the contract goes to the root of the contract. When can you not? You cannot have the remedy of cancellation and restitution in the following instances. If the defect is not so serious, if the thing can't be given back, it's not capable of redelivery, if the purchaser has delayed the claim, so you knew about it, but you took your time getting back to the seller, or if this purchaser has exercised acts of ownership. So in those 4 instances, you will not be able to cancel the contract. But you are still not, Haiku, without remedy, because there's a third possibility, namely a claim for price reduction, which is always available, where if this latent defect, so I sold my phone to Magdalena, but the camera doesn't work that well. But all in all, so I'm not a merchant or a manufacturer, and I didn't give any guarantees or anything. So she can't claim damages from me. It charges, she can phone, whatever, she's got WhatsApp, all of that, but the camera doesn't work properly. Working under the impression on the basis that the camera isn't that important. So it doesn't go to the root of the contract. She still has a working phone. So it's not that serious. So she can't cancel and get her money back. But she paid $1,000, and without a working camera, it's really only worth $750. She can claim for price reduction. So I have to refund her $250, the balance between what she paid and what it is actually worth. So Heike, to get back to your query earlier, there are always remedies, even in a second-hand sale between people, somebody that isn't in the business of selling, but just sells something because they want to get rid of it. Advertise it on Facebook Marketplace, whatever. You can't necessarily claim damages, but it doesn't mean the law doesn't look after you. There is always still a possible claim for price reduction. Is everybody with me now?
Yes, thank you.
Just a quick hint for those that are listening. That's in the test, in test 1. Make a note if you want to. Okay, so when is this guarantee not available? It's an implied guarantee. Comes with a contract of purchase and sale. All you need to agree is to buy and sell the price and the thing. And this guarantee is inherent, is there. When will it not be available? If the parties, okay, obviously it's not available if it is not a latent defect. So if you can't prove those requirements, then there's no latent defect, then obviously there's no guarantee. But also, to exclude it. Which is known as a footsteward sale. Footstewards, an agreement to buy or sell as is. With all defects. So when I sell my phone to Magdalena, we agree, I say to her, okay, you can get it for $1,000, but you're buying it footstewards. And she agrees to buy it footstewards. Then she has agreed that if there's something wrong with it, she will not come back to me. This has to be expressed. It is never implied. If we didn't agree expressly that she's buying it footstewards, then the guarantee applies. A footstewards agreement will not protect the seller. So even if we've agreed that she's buying it footstewards, I'm not protected if I knew about this, but I failed to disclose it. So I knew it doesn't charge, and I say to her, okay, you can have it for $1,000 footstewards. And she says, fine, but I know that it doesn't charge. Then that footstewards agreement falls away. Or if I made misrepresentations. So I told her, okay, $1,000 footstewards, it's in a perfect condition. So it's basically a misrepresentation. In that instance, then that footstewards clause also falls away. Any questions? Yes, Heiko.
So it looks like this whole clause may not be done with somebody that is a narcissist. Sorry to be so rude, but it sounds like this.
In essence, yes. In essence, yes. Foot stewards is not going to protect a seller that is trying to cheat. That's what it boils down to. If you're a cheat, let's not use the term narcissist because that might be difficult to fit that into law. But if you're a cheat, the law isn't going to protect you. Okay. So those are the duties of the seller. The purchaser has some duties. They are discussed on page 51 and 52. Bottom of 51 and 52 is just half a page. I am not going to do them in class because they speak for themselves. They are straightforward. If I say I'm not going to do them in class, I don't mean you can leave them out. I mean, read through that 2.5 pages. But at most, they will be sort of 1 or 2 mark knowledge-based questions that I chuck into an assessment because I'm at 49 marks and I need 1 more mark, that type of thing. So I'm not going to waste valuable class time on that. Time is up in any event for this class. This is all the work that we need to do before test 1. I want to start doing revision with you on Wednesday. Because the test is in the middle of the week, your test is next Wednesday, face-to-face in Auditorium South. I'll see how far we get with revision on Wednesday. And if I'm satisfied, I might decide to cancel Monday's class. I'd rather give you that time to study. But we'll see how it goes. But I want to do serious revision on Wednesday. Please, before Wednesday, go through your work so that if you have any questions, you can ask them to me in this revision session. So 1 or 2 things I want to discuss with you, specifically how to approach case study problem-solving questions. There's some techniques involved, so I'll do that with you on Wednesday. And then if you have questions, please ask them to me in class on Wednesday, or in the meantime, on the group. Thank you very, very much. Have a wonderful evening further. Bye.
Thank you.